I promise I will keep this brief. The real reason is I know most of you are not here because you're looking to be a tax buyer. And if you are here because you're looking to be a tax buyer, you're in the wrong room. You really need to go to seminars that are way more detailed than what you're going to get here. This is just touching the surface of what a tax sale process is. So this is going to be looking more at the avenue of you having a client whose taxes have been sold, because realistically as attorneys, that's what you're going to come across more so than somebody coming into your office saying, I want to buy taxes. If they do, that's great. God bless you. But go to some different seminars and really learn what you're doing, because, as I said in the earlier seminar, this is full of deadlines. And if you skip a deadline, you've just cost your client their investment. Certain deadlines that you violate, you can never turn that tax lien certificate into a tax deed. You may be able to get them their money back, but that's the best you're ever going to do. So you need to be very careful if you're going to start giving clients advice about what they should or should not be doing as a tax investor. Completely different, obviously, if your client has their taxes sold. So in this particular circumstance, we're going to deal with taxes that have been sold. Jeff went through the different types of tax sales. And the good thing to remember is once the taxes have been sold, the process after that is completely the same. It doesn't matter if it was at an annual tax sale, scavenger, or forfeiture sale. It also does not matter if it was in Cook County or Will County or Sangamon County or any other county in the state. These are governed by the state statutes. There are some slight variances with Cook County because Cook County, because of the population, always has a little bit of special preference under certain things, and there's certain situations that it's a little more complicated for Cook County to deal with as opposed to other counties. But other than that, everything is the exact same. Now, once a tax purchaser has purchased at a tax sale, and be it any type of the three different tax sales, the first thing they have to do is prepare what's known in the industry as a 22-5 notice. And this notice is called 22-5 because it's pursuant to Section 20-5 of the Property Tax Code. And it has a form. In the Property Tax Code, there is a specific form that you must follow. And it lays out the language. It's fairly simple to follow because there are blanks, and you have to fill in these blanks. And the blanks are, you have to identify the property sold by the permanent index number. You have to identify the certificate number for those counties that issue certificate numbers. The year sold. You have to identify the property by a location. And you have to identify when the pure redemption is currently set to expire. Now remember, based on the different types of tax sales, the original expiration of pure redemption can be anywhere from 6 months out to 2.5 months for the original expiration date. Tax buyer can always extend any of those out to a maximum of 3 years, but it can never be less than 6 nor more than 3 under any circumstances. But these dates have to be put in this original notice. This notice is then delivered to the county clerk to be mailed to the last SSC on the warrant books at that time. The last SSC is a fancy way of saying the person or the address where the tax bills are mailed. In your collar counties, more often than not, the tax SSC is going to actually be the property owner. In Cook County, that's not the case. Vacant lots, the tax SSC a lot of times will be occupant at 123 Main Street, or there won't even be a street address. If that's the case, and your tax SSC is a non-existent person or a unreal address, you still have to use that. That's where it has to be mailed to. The statute says to be mailed to the last SSC on the warrant books at that time. That's where you send it to. So you prepare this notice, deliver it to the county clerk, they mail it out. If the tax buyer fails to have done this notice, they can never get a tax deed. That tax certificate that they just purchased 5 months earlier can now never ripen into a tax deed. This is an absolute must. So if you're looking at your client comes in and says their taxes were sold, one of the first things you might want to ask them is if they ever received this original notice. Because if this notice didn't go out, your client has a good chance of setting aside a tax deed if they try to file one. Next, we'll deal, well, the expiration dates Jeff has already touched on, so I'm going to skip the expiration dates. If you realize what you have in the type of properties between 6 months and up to a maximum of 3 years. If you have residential property, if your client has residential property, it's 2.5 years minimum. Doesn't matter what kind of sale it is, doesn't matter how many tax years were included, it can never be reduced. It's a minimum of 2.5 years if they live there and it's residential property, and a maximum of 3 years. The next step for the tax buyer, after they've prepared and they've delivered this 22-5 notice, is to start deciding if and when they want to file their tax deed proceeding. A tax deed proceeding is akin to, if you will, a mortgage foreclosure. The court already has jurisdiction over the property. Remember, this is an in rem proceeding. This is not aren't required to serve persons, and we'll get to that later, but it's not an in personam requirement. It's an in rem proceeding over the property. So the court acquired this jurisdiction, as Jeff said earlier, at the time of the application in order for judgment of sale. But you still need to file the tax deed proceeding. And in the tax deed proceeding, you need to lay out the tax sale, the property sold, and then you have to serve parties with an interest in the property. And this is any interest in the property, and I mean any interest. If you think someone has an interest in the property, but they might not, you better name them and serve them, because they are going to be required to be served with notice of this tax deed proceeding. So the tax deed petitioner is going to file the tax deed petition, and they're going to send out a couple sets of notices. These notices are going to be very similar. One we commonly refer to as the sheriff's service, the sheriff's notice, and the second is going to be the clerk's notice. They're almost identical in form, except that one, the sheriff of the county in which the property is, will serve this on interested parties. And the second notice, the clerk's notice, will be mailed by the clerk of the circuit court by certified mail. And that second notice goes to owners and occupants. That first notice by the sheriff goes to anyone with an interest in the property. Excuse me. So tax buyers filed their tax deed petition. They've lodged these take notices, the first set with the sheriff to serve on anyone with an interest, the second one to the clerk to be mailed to owners and occupants. The third type of notice a tax buyer has to participate in is a publication. And mind you, a publication, we all know, how many people here read a publication? How many people sitting at home read a publication? Nobody reads a publication. It's archaic, and it's a form for newspapers to get money, but it's still a requirement. Nobody reads them, but it's still a requirement. 3 forms of service: sheriff's service, clerk's notice, and publication. You can't have 1 of 3. You can't have 2 of 3. The tax buyer has to have all 3 of those forms. You have to have been completed. We'll go back to the interested parties and the diligence. As I said before, any party with an interest, you're going to have owners, you're going to have occupants, and who's the occupant of the property? If you're dealing with a single-family home, that's pretty simple. It's, Mr. and Mrs. Smith typically live there. They're the occupants. If you have a vacant lot, and let's say it's a side lot, who occupies that property? Now, it might be the person living next door. If there's a swing set on it, people next door occupy that property. You have to look into the property. The tax buyer has to go out and physically inspect property to determine who these occupants are. And they have to knock on doors and find out. If there's a mortgage recorded, obviously any mortgagees are entitled to the service of notice of the tax deed proceeding, because that's the asset that's secured by the mortgage that they are going to lose. If a tax deed ultimately issues from this sale, that mortgage is wiped out. Maybe that's something we didn't discuss. So when a tax deed issues, it creates a new and independent title. So the former owners are extinguished. Mortgages and liens are extinguished. There's certain liens and federal and state interests that are not extinguished, but for the most part, let's deal with the fact that all your mortgages are, mechanics liens are all extinguished. So these are all parties that are entitled to notice of this tax deed proceeding, because that asset that they're using to secure that mortgage will be extinguished. Again, if you are representing a tax buyer, the better practice is when in doubt, add the party. If you think a party may have an interest, add them. If you've come across a party that has an interest, the only way you shouldn't add them is if you know for a fact that that interest no longer exists. But other than that, they need to be added. The next thing a tax buyer is going to want to do, in addition to filing the tax deed petition, is record a list penance. And this is not required by statute, but it's good practice because it puts third parties on notice. We dealt with the take notice of the publication. Jeff already talked about posting of subsequent year's taxes. A tax buyer, by statute, if they're going to go to tax deed, one of the requirements is that all subsequent taxes have to be paid or redeemed at their subsequent tax sales. Now, the key there is, remember, the tax buyer itself is not required to pay those taxes. If I have purchased the 2011 taxes on Greg's property here, and I'm going forward and filing a tax deed petition, but Greg went ahead and paid the 2012s on his home, and he went ahead and paid the 2013s on his home, and I'm getting ready to go to deed. Now, I have to prove to the court that those taxes, those subsequent taxes, those 2012s, 2013s, have been paid, and that's all. I did not have to be the one to pay them. They have to have been paid. If Greg paid them, God bless him, thank you, and I would go forward and get a deed and it cost me less. But they have to be paid. And because the tax buyer is required to prove that those taxes have been paid, they therefore have the right to pay those sub-taxes. And this goes back to the example Jeff gave. If I've now purchased at a tax sale at a 0 rate, and then the next year's taxes come up and Greg doesn't pay them, because he has the first right to pay them, and the next day they're delinquent because he didn't pay them, I can now go in and pay them. I pay them, and I add them to this tax sale, and I get 12% on that. Now, when Greg comes in to redeem from this tax sale, he has to pay all of those. He can't just pick out the first year and pay it. And this is a common mistake that a lot of people have when they wait till the last minute to go in and redeem. And if you have clients that come to you, this may be a problem that you're going to run into. And they're going to say, the taxes were sold. They were sold 3 years ago. But I now have enough to pay for that year that was sold. The taxes were sold over $3,000 a year of my taxes, and it's 3 years later, but I have that $3,000 plus I've got interest on that. So I've got about $3,500 I'm going to go in and pay. So they go into the order, the estimate of redemption, and they find out, well, now they have to pay that year and the next 2 years. Now instead of coming with $4,000, they need $12,000, and they need it by next week. They have a problem. So if you're talking or consulting with a client, make sure they know that the tax buyer has the right to pay these, and add them. When you come in to redeem, you have to pay that entire amount. You can't piecemeal it out. Anything that's added to that, they're going to have to redeem. And that includes the filing costs if they have filed a tax deed petition. And if the tax buyer files a tax deed petition, those sheriff costs, those clerk's notice, all those costs get added to this redemption. And that's the final amount they're going to have to come in and pay on time. Otherwise, they can maybe try to argue for an equitable redemption if they can get that one past the county. Yeah, you don't care about
John, let me throw a softball question out to you. The 22-5 notice and all the and the other notices.
He must strictly comply with.
There we go.
Okay. All the notice forms in the property tax code, the tax deed petitioner or purchaser must strictly comply with the property tax code, the notices and notice serving provisions. Again, if you're going to represent a tax purchaser, that is a very important issue with strict compliance. If you're going to represent a tax purchaser or become a tax purchaser, you need to go to some more seminars, not this one. You need one that's really a lot more in depth because of what is strict compliance. The 22-5 notice used to be substantial. That's switched over by case law now, 3 cases in the 1st District. It's now strict compliance. And all I can tell you about strict compliance is when asked how strict is strict, our Supreme Court and appellate courts have said, all we can tell you is that it's strict. So that's what you have to deal with. That's what a tax buyer has to deal with. If you have a client whose property is sold, you want to take a look at those notices and see if they strictly complied. And you may have an avenue to object to the issuance of a tax deed. The reality is if someone comes to you and their tax has been sold, the best advice you can give them is redeem. Redeem timely, and you don't have to worry about these any other issues. If they don't redeem timely, then they're going to have to file some objections, either an objection to the issuance of a tax deed, a 1203 to vacate, or 1401, all of which Emmett will be dealing with later. And based on the timing of that, your avenues of success become slimmer and slimmer. The grounds you can raise to object or to vacate become more minimal as time goes on. So let's deal with a tax deed has now been filed, all the parties have been served, and the per redemption is expired. No one came in, no one redeemed. The tax buyer then needs to go to the county to prove up their case, to establish to the court that they have strictly complied with those portions of the property tax code that they're required to. In many of the counties, you'll show up on what we commonly refer to as a return date, and the tax buyer will present the judge at that time with what we call an application and an affidavit in support of the application for a tax deed. And that's a document that's going to set out everything. We filed a tax deed petition on such and such a date, Here's a copy of our certificate. Here's a copy of the title search we used. Here's a copy of the sheriff returns, our notices, and our publication. And we strictly comply with the property tax code, and we're therefore entitled to the issuance of a tax deed. Most counties, you present that to the judge, and the judge will sign it right there, providing no one else is there objecting. Cook County, the process is a little more complicated and much more timely. In Cook County, you'll show up on the return date, and if you're ready to proceed as you would be in the other counties and you've prepared your application, you'll present that to the assigning judge at that point in time, who will then sign your case out to another judge for a hearing. At a certain point in time in front of that other judge, you're going to prove up your case with the testimony of your attorney, if they did the diligence, your property inspector, and you can present the proofs to the judge at that time of everything that you did in strict compliance with the property tax code, or everything your client did in compliance with the property tax code, and ask the court at that point in time to sign an order for the issuance of a tax deed. The other counties throughout Illinois, most judges will sign the order right then, but not in Cook County, because now you have to have the transcript transcribed from that prove-up. Then you have to present the judge with a copy of that transcript and your proof of your subsequent taxes that you've paid. And then that judge will go through your proceeding and decide whether he or she is satisfied that you did, in fact, strictly comply with the property tax code. And if you did, they'll sign the order directing the issuance of the tax deed. So now you're done. You got the order directing the issuance of the tax deed. It's all good, right? No. Now you have to get the tax deed. You have to bring that order to the county clerk, and you have to pay them a fee. You have to cancel the original certificate of purchase, give them a certified copy of the order, then they will give you that tax deed. You then must record that tax deed, and this is real important for tax buyers. You have to have your tax deed recorded within 1 year of the expiration of the pure redemption. Failure to do that means your tax buy is null and void with no right to reimbursement. So if your client gives you the order directing and you do nothing else and you sit on it, you've committed malpractice. If you take that order and you go get the tax deed from the county clerk and you sit on it and do nothing else, and 1 year has expired, you've committed malpractice. Conversely, if you look at a tax buyer and they've done the same thing on your client's property and they have a tax deed but they never recorded it, they don't have a tax deed. Title does not change until that tax deed is timely recorded. Merger of prior years now. For tax buyers, there are certain remedies available to them if they've made a bad tax buy. And by a bad tax buy, I mean they went to the tax sale. Okay. They went to a tax sale, they looked at this home, and it's a beautiful home. It's worth the investment. They go to a tax sale, they buy it, they're a successful bidder, and they've got this house. They're going to wait their 2.5 years for the pure redemption to expire, but then they'll file their stuff timely. A year later, they go back out to look at this home, and it's burnt to the ground. Well, now the tax buyer said, well, no, I invested whatever, $5,000 in taxes on this, and it's now a vacant lot. That isn't worth the $5,000. By the time I put in subsequent taxes, it won't be worth it. Well, the Illinois state legislature has acknowledged that there are certain hardships, and yes, I'm using the term hardship, hardships that befall tax buyers. And the state legislature wants to encourage tax buyers to come to tax sales because, after all, that's how money gets into the revenue stream. That's how money gets into the taxing districts to pay for certain things at that point in time when they need them. So in Illinois, they've allowed this thing that's referred to as the sales and error statute. And there are certain grounds that a tax buyer can get their money back, some without interest, some with interest, when certain circumstances have happened. In that particular instance would be substantial destruction. The tax buyer would then get his money back without interest, but he would get his investment back. For an investor's purpose, that's not a bad deal. I mean, most people, if you invest in something and things go south, you've lost your investment. Here, if things go south, you get your investment back, but you didn't make any interest. That's a pretty good deal. And it's those types of enactments and parts of the statute that is what encourages tax buyers to get involved, because to some extent their exposure is limited. There's a host of different grounds for sales and errors with substantial destruction. There's grounds that are, of course, jurisdictional. If the property were involved in a bankruptcy at the time of the tax sale, The court didn't have jurisdiction. State court does not have jurisdiction over that property if it's already part of jurisdiction in federal bankruptcy court, so they couldn't have the sale. So that's a void tax sale, and that's a jurisdictional issue. That's not voidable. That is void. If the taxes were paid, and you find out later you bought the taxes, and you find out the property owner actually timely paid them, and it happens. County officials make errors. They're people too. It does happen. Somebody paid them. You'll get your money back. Those are with interest. Those are outside of your control. And there's a bunch of other grounds. You might want to take a look at the property tax code if you intend to get involved in those. The big thing to remember with the sales and heirs for these tax buyers is if they are in fact seeking interest on their sale and heir, and again, some of those grounds provide for interest, but they have to have purchased them without knowledge. There was a period in time when some tax purchasers would go to the tax sale, and there would be big ticket items with large dollars due, but they already knew that there were sale and heir grounds. Maybe there was a federal interest in the property. And federal interest you can't extinguish. You can get your money back with interest. So these tax buyers would go. They would spend $1 million on a high-ticket item that they know they're never going to get a deed to, but they're going to get interest on their sale and heir, and then sit on it for a little bit of time, like maybe a year and a half. I know it's hard to believe, Ben, and I don't know that it happened that often, but it certainly happened. And then they would go in and they get their sale and heir with interest. Well, the statute was changed to prevent those types of abuses, and that's what that was. That was an abuse. So now a tax buyer has to be able to establish that they had no actual knowledge that these grounds existed. I mean, you'd see tag, and I'm sure you saw it, Ben, you'd see where the tax buyer had bought the same property and sale and heir 3-4 times in a row. They can't do that now. So the statute's been changed to remedy some of these abuses. But the grounds are still there for tax buyers to get sales and heirs. The next thing I want to touch on real briefly, and I'm going to keep it real brief because this is one area Jeff touched on, and we could go, and this could be a couple hours long and we would get nowhere, and that's the effect of a bankruptcy on a tax sale. As I said at first, if the bankruptcy is at the time of the tax sale, there is no tax sale. If the property is involved in bankruptcy court, and it's in jurisdiction of federal bankruptcy court, and the county sells those taxes, and I buy those taxes, having no knowledge that a bankruptcy petition had been filed, and the county sold me those taxes having no knowledge that a bankruptcy petition had been filed, my sale is still bad. It is void, not voidable, void. If I don't know that and I go forward and I file a tax deed petition, and I do everything I'm supposed to in my tax deed petition, I name all the proper parties, I serve all the proper parties, I publish, everyone's served, and I go forward to the judge and say I'm entitled to a tax deed, and here's my proof. And the judge says, yes, you are, here's your tax deed. And I get that tax deed, and I then go and record that tax deed, and I own that property. That's still a void tax sale. If that's to Greg's house, and he comes in 5 years later, and he says, hey, wait, I was in bankruptcy, that's a void sale. He's right. A void judgment can be taxed at any time in any jurisdiction. So I can sit on that, and it means nothing. He can come at any point in time and vacate it because it is a void sale, without getting into issues of possible bona fide purchasers. But that's the simple application of a bankruptcy as it relates to a tax sale. It gets a little more complicated after that. If the tax sale is post-sale, if the bankruptcy is post-sale, but pending at the time I file the tax deed proceeding, I may have to go into bankruptcy court and try to lift the automatic stay to proceed with my tax deed proceeding. And I say may because there's case law out there that says I don't have to. There's also case law out there that says I do have to. The bankruptcy courts are all over the place on this. It'll depend on what jurisdiction you want to look at. And even here in the Northern District of Illinois, the bankruptcy cases are all over whether a tax buyer has to go and seek to modify the automatic stay to proceed. To file a tax deed petition, you got to remember now, in a tax deed proceeding is unlike most lawsuits, because in most lawsuits I can sit on it. And if I don't serve someone, I can go out and try to serve them again. In a tax deed proceeding, you can extend that per redemption a maximum of 3 years out. and you have to file your tax deed petition no more than 6 months prior to that. So you've got a small window there in which you have to do things. So if the tax buyer's coming up to that window when he has to file his tax deed petition, if he's going to, but the property's now in bankruptcy, what do? The best thing to do is to go in and try to seek a modification of automatic stay, or at least authority from the bankruptcy court to allow you to do that. If you don't, you run the risk that you've now violated the automatic stay in bankruptcy court, and they're going to drag you into bankruptcy court later and vacate anything you've done after that, including filing your tax deed petition. So this is where it gets trickier. And then let's say, again, the pure redemption expires, and the owner or a party in interest records a bankruptcy or files a bankruptcy on the last day of the expiration of the period to redeem. Well, automatically, under that circumstance, under 108B of the Bankruptcy Code, they have an extra 60 days to come in and redeem. Now, this isn't what we referred to earlier as an equitable redemption, but the Bankruptcy Code gives them 60 days. No ifs, ands, or buts about it. So if my period of redemption on Greg's house expires today, and Greg goes today and files bankruptcy without getting into the issue of whether it was 6:30 at night, and he files for bankruptcy, he now has, under 108B, 60 days to come in and redeem. Okay. Well, let's say he has his 6 days, but he doesn't come in and redeem. Now what's the effect of the bankruptcy on the case? It always used to be our position that it doesn't matter now. He's had the time to redeem. That time has expired. He no longer has an interest in the real estate. Well, he does still have an interest in the real estate because I don't have a tax deed yet. So I still had better go into bankruptcy court and get down on my knees and ask those federal judges to let me proceed. They may let me, they may not. It's going to be the luck of the draw. A more interesting twist has just come out recently within the last week. And this is just to give you an idea of the chaos that bankruptcy, which is a federal law, challenging a state law, has created. And remember, when you go to federal bankruptcy court, that's federal court. Those judges don't care about state courts. They don't care about our state statutes. They never have. I actually went to bankruptcy court one time, and I was talking to I was pleading with the bankruptcy judge to follow state law. And I said, Judge, this is what the property tax code says. This is what the Illinois statute said. And the federal judge said to me, point blank, he said, Counsel, I don't care what state law says. You're in federal court. And that's exactly how they look at it. But to give you an idea of that chaos that they continue to put forth in bankruptcy court over this area of law, it was a situation where a tax buyer purchased a property at a tax sale, got the tax certificate, went forward, filed a tax deed proceeding. The property had 2 people living there. Both parties were served. They were personally served. Per redemption expired. They didn't come in and redeem. They didn't redeem for the amount that was sold or the subsequent taxes. Tax buyer paid the subsequent taxes, got a deed, recorded that tax deed, waited a period of time, and then sold it to a legitimate bona fide purchaser. The bona fide purchaser took that deed and paid X number of dollars for it, then went to these former owners who were living in the property and said, I now own your property. I got it through, I bought it from the tax purchaser. Would you like to buy it back? We'll enter into an agreement for articles for deed, and I'll rent it to you while you're paying back on contract. And they said, great. And so this goes on for 1 year and about 11 months and 30 days. And then guess what? Those people said, we're filing bankruptcy. They went into bankruptcy court. And in bankruptcy court, the argument was made that that was a fraudulent conveyance. The tax deed was a fraudulent conveyance because under the bankruptcy code, if the conveyance is for less than fair market value, it could be a fraudulent conveyance. And if that is a fraudulent conveyance and either the party who owned it is insolvent or became insolvent because of that transaction, that can be set aside as a fraudulent transfer. Now, mind you, this is 2 years after the tax deed had been issued. Okay, this isn't 2 years after the tax sale. When the tax sale took place 3 years later, a tax deed was issued. This is 2 years beyond that. The bankruptcy court said, yes, it is a fraudulent conveyance. And then the district court said, no, It's not a fraudulent conveyance. And then it went to the Seventh Circuit Court of Appeals, and they just ruled a week ago that, yes, it is a fraudulent conveyance. So there you have the confusion of the state of bankruptcy code as it attaches to our little area of Illinois statutes. I don't know what it is right now. So if you are involved, if your client is a tax buyer and there's a bankruptcy involved, we typically advise our clients to go ahead and get a sale and error, because the property tax code allows them to get a sale and error, and it's the safest thing to do. And that was before we knew that they now can actually own the property for 2 years and lose it beyond that. If you have a person who is about to lose or has lost their home through the issuance of a tax deed, oh boy, I'm going to get in trouble for this, but you might want to look in the file in bankruptcy and see if you can get it back for them right now before it changes. That's it. Sorry, I went wrong on here.
John is obviously just touching on the point. You know how we're here for 3 hours. We could take 6 hours and talk about the effect of bankruptcy in relation to tax sales and tax deeds. And in fact, usually through the year, our committee, if not the main committee, one of the subcommittees, we do have a speaker come in, and we talk as a group about that, because it's an evolution of the law. Obviously, it's been around a long time, but in regards to this issue, it's evolving constantly, and it constantly has to be addressed. Probably the thing to remember in regards to clients, no matter if they're a tax buyer or a property owner, in regards to tax deed proceedings, is the key words: strict compliance. This statute, it bites, and it bites hard. Strict compliance, number one, is the one thing that's going to either get the tax deed petitioner or the time requirements. If you open up the statute, the time requirements are also equally as deadly and very difficult to stay in the realm of those time requirements. And procrastination is the do-all to end-all in regards to a tax deed case. If the die date is tomorrow and your client brings and has that tax deed to record, and you go to record it on a property that's located in the city of Chicago, well, guess what? You're not going to be able to get it recorded because you don't have a water cert. And if you think you're going to get the water cert today or within 24 hours, you're not. And these are all issues that we've seen raised in court. So, and again, we could talk about those for hours. So here we have this road that's gone down where you've got the client that hasn't paid the taxes, and now it's gone to a tax sale, and now it's gone down the tax deed road, as John explained. And what relief remains, or is there? And this is the last time I'll say it, but I pulled another former chair of this committee, Emmett McCarthy, to tell you what relief is available in regards to tax deeds and tax deed cases. Go ahead.
Thanks, Greg, and all the prior speakers. I guess I'm batting cleanup here for everybody. But one thing I would say is you sort of heard the full timeline from assessment of property, levy of taxes, tax bills, what happens to get your taxes reduced, what happens if they don't pay them, what happens if they're sold. You've heard everything. And I kind of echo what Greg was saying. There's strict compliance with the property tax code as it applies to tax sales. I always say timing is everything. I actually we give some in-house legal seminars for some of our clients. At one point a few years ago, I wrote an article literally called "Timing is Everything." If you're looking under CBA materials, I think it's CBA page 101. I just threw it in here. It's kind of a summary of all the stuff we've talked about as it relates to tax sales, paying your taxes, redeeming under protest, sales and errors, objecting, all that. So if you want to start with that when these issues come up, the reason I wrote it is because I always tell clients, if they call, we want to know a handful of things. What was the date of sale? What taxes were sold? Has redemption expired? Do you know what redemption is? Do you have any idea what the redemption amount is? So you want to figure out some basic questions, whether you're going to be representing a tax buyer or you're going to, more likely for most people here or watching, are going to be representing property owners. So As you may have gathered, I don't do the assessment side of real estate taxes. I like to say I do everything other than assessment side of real estate taxes. But the tax sale side is a very niche kind of practice area. My estimation in Cook County is maybe 10 to 15 practitioners. Outside of Cook, there's probably only a handful more of those. And a lot of those practitioners are in-house counsel for tax buyers themselves. So it's hard to find somebody who's well-versed in this. I mean, looking at the people here and a few of the prior speakers, we're all litigating against each other. So it's a lot of familiar faces. But and to some extent, someone once told me, practicing in the county division of Cook County is like practicing in a small county. I've never practiced in a small county other than going out to some of the collar counties here and there, but it's great because we've litigated against each other. Everybody knows the judges. Almost everybody knows each other. A lot of the issues that we're discussing, and we could give a whole seminar on strict compliance, we're all pretty well versed in it. So anyway, the other thing I would say is the Cook County websites have improved quite a bit over the years. I remember for the longest time you couldn't even look up tax sale, tax deed cases online. Now you can search them by case number if you know the case. You can search them by PIN if you know the PIN. If you have a unique property owner, interested party, if you're searching for Joe Smith, there's going to be a million cases. If it's someone with a unique name, maybe you can search by name. But previously, we couldn't even do that. Now, I would say I would use a lot of the websites as a tool. I was searching for a tax deed case I knew was filed. I punched in the PIN. I punched it in probably 2 or 3 times. I thought I was dyslexic or something. The case never came up. For whatever reason, when that case was entered on the circuit court website, they must have transposed the PIN. So until I got the actual case number through another resource, I couldn't find the case. Cook County Clerk's Office, they now have a lot of information regarding delinquent taxes. Cook County, you can't get estimates of redemption or even estimated estimates of redemption, if you will, online. You can get those in other counties. I know Lake, I think, will. But anyway, the point is there's a lot of information available on the website to at least get the wheels rolling. So when I field calls, I'm usually asking, give me the PIN number. I try to get some basic information, and while the client is talking or, while they're digging up their papers, I'm punching numbers into the computer to try to get as much information as I can. Anyway, so the one thing I would say is most of, we represent a lot of banks, title companies, local tax buyers, national tax buyers. Most of the questions that come in where people really don't know what's going on either come from referring attorneys who want to refer a client who has a tax sale issue, they're not sure what it is. But occasionally it's tax buyers, whether they're out-of-state tax buyers that are new to Illinois, they are out-of-state tax buyers who tried to, or any tax buyer who tried to kind of wing it themselves the first time around and got burned, and now they're looking to do it correctly. Or, we call them like mom and pop tax buyers. We have a lot of clients who might buy 1 or 2 certificates. Maybe they live in this house for years. They've been cutting the grass next door, and they think, it would be nice if we own this. We don't want anyone to take it. Our pool's encroaching or whatever it may be. So the one thing I would say is they have to be aware that within 4.5 months after the date of their tax sale, they have to have done the 22-5 notice. So it's a form, filling it out. Some people think it's easy. We litigate that issue quite a bit ever since the Glory case in 2011, 2010, whatever it was, because now there's strict compliance. I can, off the top of my head, I'm looking at the practitioners here. I think we've all litigated. What is the location of the property? Believe me, you can argue about what is the correct location. Vacant lots, properties that have span of multiple addresses, properties that have 2 zip codes, you name it, we've litigated. So, and I probably get a call, I don't know, maybe once every other week, once a month, someone calls, says, I got a certificate. I think there's some legal procedures. What do I need to do? I say, okay, well, I'd like you to send me a copy of your certificate and your 22-5 notice, your 4.5 month notice, your take notice that was tendered to the county clerk. And then if there's a long pause, I know that they're not getting a tax deed because they probably didn't do the 22-5. And so we are sort of in cost recovery mode, meaning maybe they can still get a redemption, maybe there's a sale in error, they can get their money back, but they're definitely not getting a tax deed if they didn't do it, or if they did do it and it's grossly erroneous. There's obviously some gray areas in terms of did you strictly comply or not, but that's a problem. So anyway, in the big scheme of things, we get these calls. As John said, you get a call from someone, it's prior to the redemption period, you tell the client, do whatever you can. I say beg, borrow, and steal. I'm not asking them to steal, but you know what I mean. Do what you need to do to redeem the taxes. The next thing is usually we're getting a call, or I shouldn't say usually, frequently getting a call, redemption period has expired. Maybe they're one of these people that got served with a take notice. Maybe they got the initial 4.5-month notice a few years ago. They saw the redemption period was 2.5 years away. They say, I got plenty of time. About a week before the redemption period expires, they saved up their 2010 taxes plus what they think the interest is. They wait till the day before. They go there. Whoops. It's 2010, 11, 12, 13 with penalties, with court costs. There's no way they can come up with the money. Maybe they file for bankruptcy. Maybe not. So we get a lot of calls. The redemption period just expired. What do we do now? So the first thing you can do in that scenario, and if you're following along on the CBA outline, it's page 88, is file objections. Now, you don't just file random objections, but you can look into the tax deed proceeding, look into the public records, see if the tax buyer strictly complied with the property tax code. Maybe they got a bad 22-5 notice. Maybe they didn't name and attempt to serve interested parties. Maybe they didn't do a very good job of finding where interested parties lived. Maybe they missed a mortgage company on an assignment. Maybe they missed the tax servicer for the mortgage company. There's a plethora of potential arguments out there. The next, and one thing to keep in mind too is people frequently, we have to remind clients that if you win in a tax deed case, meaning you're the property owner and a tax buyer is about to get a deed, or they have gotten a deed, and you're able to prevent that deed or you're able to vacate a deed that they just got. It's not a windfall to the homeowner. It's not like, tax buyer sucker is stuck paying all my taxes. The tax buyer is going to go get what we call bona fide attempt sale and error. The court will say, tax buyer, you're not entitled to a tax deed if they haven't gotten one yet, but we see you made a bona fide attempt. They'll get a sale and error that way. If they've gotten a deed already and you are able to vacate it within 30 days, then Section 2280 of the Property Tax Code kicks in, and that dictates what the successful party vacating a tax deed is going to need to pay. So, frequently you're doing your client interview. You want to find out what kind of money they have to deal with this tax issue. Obviously, the attorney's got to get paid, but you don't want to win a case only to see them really lose, and they could lose two ways. One is if you prevent the tax buyer from getting a tax deed, they go to get a sale and error, all those taxes open up. You may have bought your client more time to deal with the tax issue, but more time means more money. So depending on how you look at it, you want to see what the tax buyer is going to get via sale and error. You want to see what the redemption amount was. You want to see what those open item tax bills will be, and kind of compare and try to work with your client to see what the best options are. If a tax buyer has already gotten a deed and you're seeking, to vacate it, the last thing you want to do is run up all these attorney's fees, and tax buyers, they're going to litigate. Unless you got a slam dunk case, you're going to pay money to litigate, just like any other case. You don't want to win, have your motion to vacate granted, client has 90 days per the Section 2280 to come up with the money and then not be able to pay. Now you've, lost sort of twofold. So those are things to kind of think about. There are certain grounds where you can vacate tax deeds at any time. John touched on their jurisdictional grounds. The taxes are paid. If it turns out, lo and behold, the county made an error, maybe somehow they were paid and there was some transactional issue. If the taxes are paid, the court never obtained jurisdiction over the property. If there was, it's exempt. That's churches, municipalities, charitable groups. That's, again, a whole other discussion because sometimes entities are not exempt per se. I would call them exemptable. They haven't gone through the process, but that's one ground. Obviously, if it's owned by the state, a municipality, you would think those would be sorted out of tax sales, but they're not. Mostly tax buyers find that out and they go get a sale and error themselves, or the county initiates a sale and error because they accidentally sold some state-owned property. And then, as John mentioned, bankruptcy before the sale. There's also due process arguments. Again, that is a big-ticket item, even within our field at our own little subcommittee CBA meetings. We're arguing about when you can raise due process types of arguments. So those are direct attacks, meaning before the tax deed is issued or within 30 days of that court order. And again, it's the court order being entered, not when they record the tax deed. Once you're beyond that 30-day period from when the court order is entered, now you're in what we call 214.01 territories. Section 214.01 of the Code of Civil Procedure in conjunction with Section 2245 of the Property Tax Code. So you're bringing it after 30 days, but within a 2-year window of the court order. Now your arguments are limited. You're down to really 4 grounds. Taxes were paid, you can raise it at any time. Property was exempt, again, you can raise them at any time. Subsection 3 and 4 are the ones that are usually litigated, and that's that the tax deed was procured by fraud or deception on the part of the tax purchaser. You know, the easiest example of actual fraud would be the tax buyer tells the court it's a vacant lot. It turns out it's somebody's house. That's probably actual intent, scienter, whatever you want to call it. We're usually litigating more narrow issues. Tax buyer said that everybody was properly served. They didn't serve everybody. Tax buyer said the property was located at a certain address. Technically, it's not really at that address. It's maybe around the corner. So there's a lot of case law on what fraud means in the tax field. There's some courts that will say that misrepresentation or that representation was tantamount to fraud, whatever that means. So, and then subsection 4 is sort of like a due process. It's parties with a recorded interest in the property, and the tax purchaser didn't make a diligent inquiry to name and serve them, and they also weren't named in the publication notice. But, you know, we've had issues where, let's say, a mortgage company, and again, you know, sometimes title is complicated, but we've had situations where a mortgage company or some other party with an interest wasn't named or served, period. Then the issue becomes, well, you're limited to the 2 years of 21401. I'm of the opinion that no, you have due process grounds, which even if it's beyond 2 years, you can still raise them. The other thing that comes up occasionally is there may be a tax deed proceeding, and I'm not going to touch on the most recent bankruptcy case in terms of bona fide interest, but putting aside bankruptcy, you may have a situation where a tax buyer gets a deed, and you as the practitioner who's representing, let's say, the former owner of a mortgage company, what have you, you start looking through it and you say, oh, wow, the tax buyer didn't really do a good job here. We think they missed some parties. We think maybe there's some fraud on the court. Then you check title and you see, whoops, you know, tax buyer doesn't own it anymore. You know, it went from, you know, professional Illinois tax buyer to someone who lives down the street who's, you know, paid what looks like pretty fair consideration. Now you have to think about, are they protected by the bona fide purchaser provisions or bona fide interest? And so that's another hurdle you're going to have to overcome. And again, that gets back to timing. So we are frequently, you know, if we are retained and we're reviewing a file and it's still owned by the tax buyer, the clock is kind of ticking. Now, if you have someone in possession, maybe they can't establish a bona fide purchaser, but maybe you got a vacant property, not vacant property, a vacant building, tax buyer's marketing it. If they sell it to a bona fide purchaser before you get your foot in the door, you know, you're going to have some problems there. I already touched on 2280. Generally, under 2280, if you're the party vacating a tax deed, you are going to be paying the amounts pursuant to 2280. They're not exactly the redemption amount, but an easy way to think about it is redemption plus additional interest. Under certain grounds, if it turns out it was exempt, this comes up maybe where a charitable organization or something vacates a tax deed, they establish their exemption, maybe the taxes should have never been sold, it might be on the onus of the county to pay the 2280 rather than the tax buyer. Kind of last but not least, and I don't want to minimize this, I think Ben or prior speakers touched on this, the Indemnity Fund. So the Cook County Indemnity Fund and other counties have indemnity funds. It is basically, in a nutshell, funded by various tax sale surcharges. It used to be a $80 surcharge plus 5% on postings and so forth. Now it's just the $80 fees. Indemnity fund is for people who have lost their property through the tax sale process. There's different provisions for owner-occupants. Owner-occupants, if they're only seeking up to $99,000, they're under what we call the equitable entitlement standard. If it's an owner-occupant who's trying to get more than $99,000 or any other property owner, they're under what they call the no-fault or negligence standard. The no-fault or negligence, I come from a PI and mail background before I got into this, and it's not the exact same as that type of fault or negligence, a little more liberal. There was a recent Supreme Court case that had nothing to do with the Indemnity Fund, except at the very end the Supreme Court said, maybe this is a case that should go to the Indemnity Fund. So, you know, you can look at it as your remedy of last resort. So, you know, most of the cases are owner-occupant type of properties, but there's other properties as well. I should mention you're always capped at the fair market value of the property as of the date the tax deed was issued. And one issue that comes up frequently is I'll give it this example. You have a property that's worth $100,000. Person has the best indemnity case ever, but they got a $50,000 mortgage on it. So what happens? They file for indemnity, maybe you settle the case. The most they would ever get is $100,000, but $50,000 would go to the mortgage company. That one's pretty easy. Well, now what happens if it's $95,000 going to the mortgage company? Does the person really want to pursue it if they're maybe going to get $5,000? So there's a lot of negotiation potentially between the former owner and counsel as the former owner and certain lien holders, to maximize what the recovery may be or to work out a deal where the lender is maybe taking less money to release the promissory note. The mortgage would have been wiped out by the tax deed, but you may have to negotiate there. There's more to the indemnity fund, but I do want to leave maybe about 15 minutes to discuss it. So the last thing I would say about the indemnity fund, and I was just thinking about a case I have now, there is a potential for not only the indemnity fund or the county on behalf of the indemnity fund to bring third-party claims. Say it was the mortgage company that had an escrow. They didn't pay the taxes. The county can bring them in. Say it's a title company, screwed something up at closing. They put a tax bill in their file, closed it up, off. They never paid it. Maybe the title company's on the hook. There might be some other third party other than the tax buyer. Tax buyers cannot be third-partied in. But as counsel for the indemnity petitioner, occasionally you may preemptively bring in those third parties. So you may have claim one is petition for indemnity, alternative count, or additional count is claims against title company, claims against lender. The indemnity fund may eventually bring them in, and it's a strategy decision in terms of how you want to do it. So anyway, they're interesting cases, and it is sometimes a nice way to not only get money for the former owner, but frequently that money that they get, they use to repurchase the property from the tax buyers. So I will leave it at that. And like I said, the timing is everything, which is a 2-page synopsis begins on CBA page 101. That's sort of a quick summary of some of the options. So thank you.